Good morning, Your Honor. Timothy Bradle on behalf of Aidan Kearney.
Good morning, Mr. Cosgrove. Mr. Bradle.
And for Mr. Kearney, Mark Federer. Good morning, Your Honor.
Good morning, Mr. Federer. Okay, just to be clear, we've accommodated as many people as we can in the audience. I understand there are some folks outside. The court has opened the matter to Zoom, primarily because of the weather and the parking conditions. I'm not going to say that we're going to have it on Zoom every single time, but to those who can't be in the courtroom right now, we are broadcasting by Zoom. Further note, the court was prepared to come out at 9, but the delay was due to the late arrival of some of the counsel. So, with that, I would remind all parties who are attending by Zoom that any rebroadcast, if you are not qualified under SJC Rule 11119, rebroadcast is prohibited. Those who are qualified and have registered are certainly free to rebroadcast as appropriate. So, with that, my intention today is to cover papers 110, 117 in part, 125, and 127. Those are the matters which deal with the request for the recusal or removal of Mr. Cosgrove as counsel for the Commonwealth. Now, before we begin that, particularly Mr. Pepper, just to you, I know Judge Newell may have talked to you about this a little bit. Going forward, we don't file affidavits as motions. Rule 13 requires a motion to be a motion. It can be supported by a memorandum of law. It can be supported by an affidavit. The matter we're here for today, there is in fact no motion on file. I'll take it as it sits because it's been responded to. But going forward, if you want to file a motion, it has to be a motion. It has to be clearly captioned as to what you're looking for. Further, it has to deal with one subject at a time. We're not going to do motions that deal with the entire kitchen sink. It's going to be one motion at a time. It's going to be clearly noted. If you want to put a memorandum of law, again, you have to reference the motion you're dealing with. Further, if you want to put an affidavit, the affidavit has to reference the motion that you filed. If you want to put in a supplemental motion or a supplemental memorandum, it has to list the paper number that you're talking about. Going through this over the last several days and trying to figure out what I'm dealing with took an amount of time which is kind of absurd because I'm trying to trace back what you're talking about and I can't find the motion because it doesn't exist. So I understand you're not local to Massachusetts. Mr. Bradle is extremely experienced and quite good at drafting these things. So,
Judge, I was going to say that's my fault. I'm local counsel. I should have made sure that was that way, and we'll make sure of that going forward.
and I note that paper number 127 is more in the form that we used to in this court. So I just want to remind everybody where we're at. And again, not familiar with the area, that's okay. Just going forward, I don't want to have to sort of parse through what we're dealing with, nor do I want to have to hear from Mr. Cosgrove saying there's no motion filed, because it's a pretty good point on his part. So, with that, let's take up the matters that are before the court. You're the moving party. I don't know who that wants to argue, Mr. Bradle or Mr. Federer.
Mr. Federer, Your Honor.
We'll hear from you.
Thank you.
I understand I've looked at all your motions, as well as all of the exhibits.
May I, Your Honor?
You may.
Counsel states that a recent conflict of interest has developed which ethically precludes him from continuing to prosecute matters in which Lindsay Gaetani is an alleged victim or party. Those are the words of Mr. Cosgrove on September 24th, 2025, regarding his request to be removed from another indictment in which Lindsay Gaetani was a witness, and we'll get to in this argument why she may very well be a witness in this case.
Witness is different from victim, correct?
I'm sorry?
Witness is different from victim, right?
Of course, but as we'll get to, Your Honor, if a prosecutor or anyone has a personal interest that may differ from the Commonwealth's or to a defendant's right to a fair trial, that's something that has to be factored in. The point of that comment, Your Honor, is that Mr. Cosgrove acknowledged that there was a conflict arising out of Ms. Gaetani's claims against him. She has accused him of unprofessional and unethical conduct and has sued him. He draws the line.
I note that the last docket entry in that case was in the process of being settled. That's paper number 15 in that case. That was filed just last week.
Judge, whether the civil case continues or not, isn't even necessarily the issue.
Explain why that would not be a problem.
Because she has accused him, a lawyer, a former judge, of unethical behavior, and he has a personal interest, understandably so, in defending himself against that, and in any matter in which her credibility becomes an issue that she testifies in a trial, he has an interest in discrediting her, which may be very different from the Commonwealth's interest, which I'll get into as to why that may be. But the point is, calling her an alleged victim and that there is a conflict because of her allegations against me, merely being a witness in a case in which she may testify, as the difference which somehow makes his personal interest, acting both as a criminal prosecutor while serving as a civil defendant and potentially cross-examining your civil accuser and your lead detective is a civil co-defendant who has also been accused of misconduct, undermines the public confidence in the proceedings and demonstrates that a prosecutor could have a personal interest. The bottom line, Your Honor, the difference between witness and alleged victim is a distinction without a difference if the prosecutor has a personal interest which could significantly impact his representation of a party in the case. That's the Rule 1.7 issue. Now, Mr. Cosgrove has replied that, well, we're not going to call Ms. Gaetani as a witness, and that's certainly his right, for the time being anyway, as the prosecutor for the Commonwealth. But the defense may very well call her. Her credibility will be an issue, obviously, if she testifies in this case. At that point, having a prosecutor who has been accused of misconduct, who is named as a civil defendant, attacking her credibility and attempting to defend the credibility of other witnesses whose credibility could be impeached by Ms. Gaetani is a problem. It's a problem because the jury would have a right to know what the prosecutor's interests may be. It's not...
What if the jurors not to cross-examine?
That's a decision that has to be made by a disinterested prosecutor.
What if you got someone else to cross-examine?
That may or may not solve the problem. Certainly it would with the direct examination of her.
Well, he's not going to call her. He's made that clear.
I understand that. What I'm suggesting to the court is we may very well do that.
You may, and you'd have to get permission from the court to do that because you'd have to show me that it's relevant, but that's another issue down the road.
Well, I'm going to tell you right now, respectfully, why it may be relevant, beyond just the substance of her testimony. Mr. Cosgrove addressed the substance of her testimony as it relates to the allegations against Mr. Kearney. She also may very well be a witness who can expose bias of other important prosecution witnesses, who could expose conduct on behalf of some of those important prosecution witnesses, conduct which is not at all consistent.
Well, let's get to the nub of it, all right? Because I've read all your materials, so you don't need to repeat the argument to me. Look, as I understand the issue here, Ms. Gaetani, that's the correct pronunciation, is it not? Ms. Gaetani has an interaction with Special Prosecutor Mello in December, I think the 24th, was it, or the 23rd?
Something like that.
Of 2023.
Mm-hmm.
It's around that time that she's alleged to have some interaction with Ms. McCabe. Is that correct?
Amongst other times, yes.
Around that time, is my understanding, based on the evidence you presented me, around that time, Ms. McCabe urges her to go to the grand jury. Do the right thing, go to the grand jury, something along those lines. Right, is that correct?
In substance, but I think it's interpretational and the witness might expand it a little.
I understand that. All of those events occurred 6 months after the events that are in play here. So the relevance of those events is only as to the credibility, potentially, of Ms. McCabe. Now, you might be able to get into that. You might be able to even confront Ms. McCabe. But then you're going to have to raise an issue of whether or not you get into a trial within a trial, so to speak, the extrinsic evidence rule, which takes us to whether or not she is even going to be a witness to talk about potential bias after the fact. This is after the fact bias.
Yes.
On an issue which, frankly, I'm struggling with a little bit, because nobody contests the acts here, all right? Mr. Kearney is a citizen journalist, sort of a new breed of journalist, correct? He presents to this court that all of his activities are fully protected under the First Amendment. It's a very reasonable argument, okay? Mr. Cosgrove says different. He says this is witness intimidation. The motivation of Ms. McCabe to his acts is tangential, by and large, is it not?
Judge, I
Now,
know.
she's going to testify, yes, I was intimidated. But the main factor here is the nature of the comment, which is recorded, made voluntarily and recorded. Now, you are correct. There's an excellent argument to be made, perhaps, that Gaetani and Genduso and McCabe may have all had some idea that they were going to get together and get his bail revoked. But that's not what this trial's about. This trial's about what happened 6 months before. So you got to draw me to the relevance of that.
Her bias and motive against him, whether before, during, or after, I would suggest is certainly relevant. Moreover, it's
But
not.
it's all after.
It's not.
Before.
Judge, you mentioned a moment ago about the fact that she's going to come in and say, I felt intimidated, or I was emotionally harmed. I think we would all agree that would be relevant about what the impact that these horrible allegations had on her. There will be evidence through electronic communications between Gaetani and McCabe, which Gaetani may very well have to authenticate as a witness, because frankly, we don't assume or take any guess what Miss McCabe will say, where shortly after Mr. Kearney was released from jail, from what Your Honor just spoke about, where Miss McCabe recruited Miss Gaetani and orchestrated surveilling him from various police stations and to other locations, joking about going on a stakeout. In other words, conduct not consistent with her being intimidated. Those actions will also corroborate.
The intimidation doesn't have to last forever. The intimidation, we're only trying one slice at a time. That's the bedrock of any criminal defendant,
Of course,
right?
but
We're not trying his entire life, we're trying that moment.
But these are questions that have to be posed to Ms. McCabe, and she'll have and should be forced to answer them and explain them.
I don't necessarily disagree with that.
Okay, so the point is, we don't know what Ms. McCabe will say. We know, based upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
Which seems to move with time from poll to poll, correct?
I'm not sure what you mean.
Well, it seems like her allegiances have changed as this case has developed.
She is, without question, a unique witness, which raises another interesting point, which could lead to the possible conflict with Mr. Cosgrove. She is a former prosecution witness, there's no question. She testified in grand jury. She testified at a trial called and vouched for by Mr. Cosgrove.
Quite enthusiastic, as I understand.
I believe so, Judge. That, no question. And at that point, they had no problem with Ms. Gaetani. But at this point, she's now sued Mr. Cosgrove. She has sued Tully. She has threatened to sue or sent a demand letter to the DA's office. And when that happened, Mr. Cosgrove said, I have a conflict with her because he has a personal interest in seeing her discredited. And I'm going back to what I first started with, Your Honor. The issue is not because she's an alleged victim. She's a potential witness in this case, and the prosecutor has a personal interest in seeing her discredited. And the critical part comes in the argument to the jury at the end of the trial. When McCabe has testified, it's in Mr. Cosgrove's personal interest that she be credited, Gaetani not be credited. When Tully testifies, it's the same exercise. He's a co-defendant of his.
What's Tully going to testify to?
What is Tully going to testify? We're not calling Tully.
Mr. Cosgrove, what's Tully going to testify to? Is he even a witness?
I have no determination as to whether I'm going to call Tully or whether I need to call Tully. It seems to me that the videos, which Mr. Kearney has himself made public, documented his statements and actions that pretty much self-authenticated. I'm not sure.
Well, I think you may have to make a choice here fairly quick if we're going to deal with this issue. But continue, right?
Look, the bottom line is Detective Lieutenant Tully is the lead investigator on this matter. Now, that doesn't obligate the Commonwealth to call him, but he is the driving force behind this. He built the investigation. He got the search warrant.
This is not your classic whodunit.
No.
This is not the investigation
No.
where they find evidence on the scene, they develop the evidence on the scene, they trace the suspects, they get phone downloads, they do this, that, the other. This is a very unique set of facts.
Very.
Where the defendant recorded himself and then voluntarily broadcast his actions to the world at large. So the investigation essentially is press record, and then a jury of his peers, all right, would judge the mores of our society to determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
The point I'm making, Your Honor, is that Tully...
And I would like the jury of his peers to make that decision. I don't want to make it. I want the jury of his peers to make that decision.
The point I'm making, Your Honor, is on this issue, is that Tully is the lead investigator. And certainly I can only speak from my own experience, perhaps others, that it would be extraordinarily rare not to call...
I don't find that to be accurate in my experience. I've seen it happen a number of times.
I've seen it happen.
Much to my disappointment when I sat over there. Okay?
I've seen it happen, and I've taken that from the other side of the table in prosecuting rather than defending, in letting juries know who built the case, what is going on here. But the point...
And fairly pointed out by the defense, and you didn't hear from it.
It could be. It may very well be, but that could also lead to the reason why. Okay? The issues surrounding Gaetani's claims, that the defense wants to argue they're not calling Tully. Perhaps the jury may be entitled, not asking Your Honor to make evidentiary rulings now, obviously, but the jury may want to know and be entitled to know why isn't the prosecutor calling it, and might it have something to do with what Gaetani alleges. But moving away from Tully to the larger point, it's not even so much the cross-examinations, which I would, or other evidence, which I would suggest are improper being conducted by a prosecutor with a personal interest in favoring certain witnesses over the one that is suing him. It's the summations, it's the argument. If Mr. Cosgrove has an opportunity to cross-examine Ms. Gaetani, assuming he does, as Your Honor noted, maybe he won't, but I would suggest, again, that's a decision to be made by a disinterested prosecutor, not one with a personal interest.
Well, let's define the personal interest. It is, anybody can bring a lawsuit against anybody, right? You know, the actions that are alleged here by Mr. Cosgrove, and most of them, apparently, frankly, seem to have occurred prior to his arrival in the case. But the actions are alleged were done solely in his role as a special prosecutor. You know, his immunity is almost impenetrable. Correct?
In a legal sense.
Sir, this is a legal setting.
No, Your Honor, my point is this. Personal interests don't rise and fall. They're not black and white because you've been sued or not sued. She has publicly and loudly accused a distinguished prosecutor of misconduct that he himself recognized after the lawsuit was filed. With this lawsuit that we're saying has no merit, what did he do? He sought removal because I'm ethically precluded from cross-examining her. It's the same issue.
Well, I'm not sure about that. I'm not sure that's what he said, but I'll take that.
Well, Judge, I just want the record to be clear. What he said was, counsel states that a recent conflict of interest has developed which ethically precludes him from continuing to prosecute matters when Gaetani is an alleged victim or party, and we talked about whether we use alleged victim or witness as the issue. The point is...
That's what I said. That's not exactly what he said. What he said was...
Yes. I'm not trying to substitute that. We're trying to, in my view, suggest that's a distinction without a difference, because he has been attacked. And when he withdrew from the other case, the lawsuit against him was no better or no worse than it is now. So he didn't make that argument back then to say, this is some garbage lawsuit, I have no real conflict. What he said was, I am ethically precluded.
I take your point. Mr. Cosgrove, if you're ethically precluded from one, why aren't you ethically precluded from two? I'll come back to this issue of the 2025 investigation too.
I reserve my answer on that part.
Reserve it for when?
For when it's my turn to speak.
I was about to give you your turn to speak, but go back to Mr. Vedero. Let's talk about the 2025 investigation.
Can I, Your Honor, can I make one point I didn't get to? We kind of
Sure.
got. It's the summations where the real problem arises here. Because if Gaetani were cross-examined by Mr. Cosgrove, in essence, it is almost a free deposition. It is sworn testimony of her by a litigant against another litigant in a civil matter in which he has the full power of the government cross-examining, which will benefit his personal interest. Then you go to summations. Presumably, his argument will be Gaetani is not believable, Gaetani is not credible, but McCabe is. Now, those are appropriate arguments by most people to make, not him, because it is in his personal interest, not just as a representative of the Commonwealth, it is in his personal interest that she be discredited. And the jury should know that. Now, I'm not saying that's an appropriate outcome either. The appropriate outcome is that he be removed, because if he's vouching for the credibility, not in a legal sense, but advocating for the jury to adopt Jen McCabe and discredit Lindsay Gaetani, the jury should not be ignorant to the fact that this guy's getting sued and wants her to be discredited. That is not the kind of thing that the public can have confidence in when they find out that the prosecutor who is judging everyone's credibility is discrediting her, crediting another, and it's tantamount to him giving unsworn testimony.
This goes back to the issue of relevance we talked about before, and this is where I'm a little bit hung up. What McCabe does 6, 8, 10 months after the allegations here, because the allegations with regard to McCabe, as I can tell, they occur on 6/6, 9/20, and 7/22. Those are the 3 dates where she's alleged to have been intimidated. So none of these matters involving Gaetani develop until perhaps December, right?
Gaetani's, some of her testimony, though, Judge, will corroborate other evidence we have of Jen McCabe's pattern of surveilling Mr. Kearney before he was indicted.
But when?
In 2023, July of 2023, we have documented evidence of her, the intimidated and emotionally harmed witness, contacting Mr. Kearney on social media and alluding to the fact, I know where you are, which is exactly what we're talking about with Gaetani.
That's a fair point to cross-examine her. No doubt.
Don't know what she's going to say. From our perspective, having seen some of her other testimony and other proceedings, we don't just assume that she's going to be forthright. And we have a right, she's the star witness of this case.
I mean, you need to know a little bit more about that. In terms of, if you want to file something and pound it to me, that's fine.
The final point I'll make, to Your Honor, before you have any other questions, is it's important that we're raising this now. This is well before trial. The prosecution is clearly on notice. I don't know where this may lead to, what else could be discovered. You know, this is a unique case, as you've noted, and evidence is discovered in all kinds of odd ways, believe me, with how these cases proceed and who shares what and those kinds of things. It's critical for us to make this record now, alert the court respectfully,
No issue with you making the
and
record.
because if it comes up later after a jury is impaneled, there is a risk of a mistrial, and that will not be our fault, and we think at that point.
Listen, Mr. Vedero, I have no issue with you bringing the motion. You need to advocate for your client in any way you think is appropriate. I'm just trying to flesh it out here, so I understand
Understood,
exactly
Your
what the
Honor.
issues are. I'm struggling with the relevance issues. You may have to give me more information on that, so I understand it a little bit better, because the way I read things, they're much later in time. Now, if you've got something that's more contemporaneous to the alleged intimidation, I think that's very, very relevant. and we'd have to sort of play out how that would come in and what that flow of that happens. So we'll come back to that at some point when you're ready to talk to me about that. But talk to me about this. Your motion had 3 parts. Your affidavit had 3 parts. One was the 2024. That's moved because it's already been done. The second was this issue. The third was this idea that I could preclude the executive branch from investigating things in 2025. Can you give me some authority which says I have the ability to do that?
It's a unique situation, Your Honor. I'm not going to sit here and tell you that there is a case law roadmap to what's happening, but what's important to recognize here, you've been asking us these questions about how is Gaetani relevant. She is extraordinarily relevant to what we're calling the 2025 investigation, which results in these search warrants for the phones of Karen Reed.
Which is still pending with Judge Crump.
Right. That search warrant.
Let me play that out 2 ways. What if Judge Crump says he can have access to the phones? Then we're going to have a much longer issue, correct? Is that going to come into this case?
Well, they're telling us that 2 people are under investigation. I mean, it's hard for us to know, right? I mean, they're attempting allegedly to indict Mr. Kearney and Karen Reed for actions in which they already tried to indict and the grand jury said no, and now 2 years later with phones that have been gathering dust, we need to look at these phones and, God knows what we'll find. But the point is, the search warrants in that case are critical and certainly could relate to evidence used against Mr. Kearney. There are 2 informants in that search warrant. One of them is Lindsay Gaetani, and the affiant of that warrant is Detective Tully. And there are about 10 paragraphs, and I'm paraphrasing, I don't know the exact number, relying on her, and it is loaded with information which she provided them, and we're back to the personal interest of Mr. Cosgrove. So that really was meant to just inform the court that this is a living, breathing issue.
I will agree with you that it's a living, breathing issue. It's just not a living, breathing issue over which I have authority.
Fair enough.
When that comes to me, if it comes to me, I don't know if my special assignment encompasses that. We'll see. But if it comes to me, then we'll deal with that issue. I can find nothing which gives me the authority to restrict that activity.
Okay.
Judge Crump has the authority on the search warrants, and he'll make a decision in due time.
Understood.
But I find nothing which gives me the authority to restrict prospectively an investigation that's being done by the executive branch.
Judge, just before I sit down, and unless the court has any other questions, I just want to correct one last thing. Your Honor had mentioned about a lawsuit being settled. That is not the lawsuit involving Mr. Cosgrove. There's no settlement.
I looked at the docket this morning.
Not with him. That's with other parties to the litigation. It's my understanding.
Well, let me play this up for you. It's, as I said, I have some familiarity with this individual. Since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again, an accusation is one thing, but it would seem like there's a little bit more. You'd have to have some substance to it to actually disqualify. But I'll keep an open mind on it.
Does Your Honor have anything else?
No, I read all your stuff.
Thank you.
Anything more?
No, sir. Thank you.
Mr. Braley, anything?
No, Judge, thank you.
Okay. Mr. Kearney, Mr. Cosgrove, if not, if you're conflicted out of one case, why are you conflicted out of the other? That's the real big question.
Well, I don't think the 2 necessarily follow, Your Honor. Obviously, before I filed my motion seeking to withdraw in the other case, I would have been a poor attorney indeed if I didn't think about whether it also required me to withdraw in this case. And the motion to withdraw was, at least I attempted to phrase it quite carefully, to say that I had a conflict because Ms. Gaetani was the alleged victim in that case. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts. But nevertheless, it was essentially an argument that I would be making in that case that Mr. Kearney committed crimes against Ms. Kearney. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Kearney's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if it came to trial?
Well, that's a very interesting point, Your Honor. There's a couple of problems with it. One problem is the practical matter. I don't see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt the defense theory that everything is relevant to every issue, but I don't see how indicating that Ms. Kearney was not credible in making statements about the investigation of Mr. Kearney here would have any relevance to an accusation that I breached some sort of duty to her by turning over a police report, which is the contention. Also, Your Honor, assuming that this even survives the motion to dismiss, and we're talking now about the Middlesex case, I don't think there's any factual dispute.
There's nothing in Middlesex, right?
I'm sorry, Worcester, yes, thank you, I appreciate the correction. I don't think there's any factual dispute as to what happened. In my capacity as a prosecutor, I provided Mr. Bradle with the police report in question as discovery. It made its way by whatever means from Mr. Bradle to Mr. Kearney, who then publicized details of it and turned it over to a friend, an associate, whatever you want to call him, who actually put the whole report, as I understand it, on the internet and began pillaring Ms. Kearney over her credibility. I don't dispute that I turned that report over as a matter of discovery. If this case ever develops in Middlesex and comes to fruition, I couldn't possibly dispute that. That's the absolute factual truth. From that point on, it becomes a pure question of law as to whether I breached some sort of duty under the statute to Ms. Kearney under the mistaken belief that I had a Rule 14 obligation to turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias. Maybe I made a mistake. Maybe I was wrong legally. But that's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter...
How do we avoid the circumstance that she's called on the stand and there's some relevant testimony that she can offer? You wouldn't call her, but the defense calls her. And you're in the midst of a cross-examination and she says, well, this is why I sued you. What do we do with that?
I'm not sure what you do with it. Maybe we deal with that with a motion in limine to preclude her from mentioning the substance.
That's how we determine control of the witness.
That's why we have skillful Superior Court judges, Your Honor, if I could, if I'm being a little obviously self-serving in my comments. I'm sure Your Honor, both in his prior career, as I have in mind, and in your present position, has dealt with witnesses that are difficult to control.
What about the possibility of someone else bringing them? Is that something that's realistic or not?
I didn't quite hear you. Something else?
What about the possibility of bringing someone in to deal with Ms. Gaetano if indeed she's a witness?
Could be done.
Well, it would solve a lot of issues. Fairness, Federal? I mean, you're not contending that the case goes away completely. You're contending that he can't deal with Gaetano.
Unless, Your Honor, I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani, but if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard pressed to figure out why the issue of the lawsuit would come out.
It could. Again, I don't know.
But that is my job to control what comes out. But so
Yes.
legally, let's think about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think we all agree.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure it out. I guess the first question is, why are we having this conversation, and why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we have this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove
I
has
think he's
done.
not done
Fair
yet. I
enough.
just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. So it would appear to me what you're saying to me is, if there was a replacement for that issue, that would resolve this.
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility of Ms.
I
Gaetani.
agree with me. That does happen in trials, not with some frequency, but it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a statement of a defendant, they have to be a witness, these kinds of things can happen all the time.
We find ways around it.
But we're also, to be clear, we're dealing with a very rare situation where the witness is a former prosecution witness accusing the prosecutor, who she testified for previously, of misconduct. Now, if the prosecution and the court approves of that process, wants to have that laid bare, then I suppose it could. But the other problem, just
on this issue, we're not going to hijack the rest of the argument.
okay,
Just
then
on the issue
I'll
of
hold
replacement.
I had a brief response.
Yeah, he's not done.
Fair
You're going to
enough.
get to respond when he's done.
Yes.
Mr. Cosgrove.
Well, just on that point, I have yet to hear how any comment that I might make on the credibility of Ms. Gaetani's testimony in the case before the court would even come in or be relevant in the Middlesex case or assist me in any way. I'm going to go over to Middlesex Superior Court, and frankly, I find it hard to believe that I or whoever would be representing me would be brazen enough to say to the judge, well, I want to talk about all the ways in which my client, Mr. Cosgrove, impeached Ms. Gaetani in a case that has nothing whatsoever to do with the case before the court. There's just not going to be any lead through whatsoever, it seems to me. We don't even have, frankly, Ms. Gaetani's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that either the Commonwealth or the defense is going to call her in this case. Mr. Counsel counsel has carefully said we may call her for the defense. This may be a contingency that doesn't even arise, but that's sort of a side point. Let me just take a couple of points. I was going to ask Your Honor to take judicial notice of the pleadings in the Middlesex case and the docket. It appears you've effectively done that, but let me make an oral motion on the record.
Any objection?
No.
Purpose.
I agree. I will take those in judicial notice as to the Worcester Superior Court case.
And one of the interesting, unique things about this alleged conflict of interest, which is a little different from the typical conflict of interest case, at least I haven't found anything precisely on point, and I don't think the defense says either, but maybe they'll prove me wrong in a moment, is the whole operation by which this alleged conflict has come about, and the Middlesex case has come about. What is it that enables Ms. Catani to make the claim that she's seeking to make against me in the Middlesex case? It's that the defendant took the report I gave him as discovery, or I gave his counsel as discovery in the other case, publicized it, and then created the harm that Ms. Catani alleges accrued to her from that publication. In other words, if we're applying but-for causation, to sound like a tort lawyer for a minute, if we take Mr. Kearney's actions out of the whole proceeding, there's no harm whatsoever to Ms. Catani with my, as I see it, fulfilling my Rule 14 obligation. So Your Honor has the unusual situation here of a defendant who has been a but-for cause of the alleged conflict, seeking to profit from that conflict by removing the prosecutor of his case, which I think is worth some consideration by the court. What I would like to do now, Your Honor, since the defendant has had the opportunity for a reply brief, which frankly doesn't particularly go to these motions, particularly, but more to the point, the defendant's third reply in support of the motion to disqualify Robert Cosgrove. I'd like to examine that in some detail and take the opportunity to reply to some of his
It really doesn't
intentions.
become an issue here. That involves another party whose case has been dismissed. The case regarding the defendant, and that witness is gone. That's dismissed. So I don't really know that that's all that relevant. Mr. Bedro didn't even raise it.
For purposes of this, Your Honor, the briefs are what they are. We submitted them. I just raised the issues I thought would be helpful for the court today.
Yeah, I didn't find that anything with regard to that particular trooper terribly compelling, because I don't understand how he would be part of this case. Fair to say?
You're talking about which trooper?
The trooper whose case was dismissed, Bouchard.
I'm not talking about the, I'm sorry for interrupting you, Your Honor. I'm not talking about the motion that they filed with respect to discovery for Mr. Proctor.
Oh, we're dealing with discovery right now. Yeah.
I'm talking about the motion that's captioned, "Sir, reply in support of motion to disqualify Robert Cosgrove."
Paper 127, you're talking about.
I don't know the number, to be honest with you, but,
This one here?
yes,
Yeah,
exactly.
that's 127.
Okay.
Okay, go on here.
So, defense begins by complaining that my response envisions my conflict in a vacuum, and that it ignores the whole context, which is basically a preface, Your Honor, for talking about everything else that the defense is unhappy with about the case, except issues that are relevant to whether or not I should be disqualified. There is, on page 1 of that motion, the suggestion that Mr. Morrissey recused his office from prosecuting Mr. Kearney due to a conflict created by an investigating journalist who publicly accused the DA's office. I'm not sure that Mr. Morrissey has made a statement explaining why he appointed a special prosecutor, but we're stand to be corrected, but certainly this is the explanation that might sound most favorable to the defendant. But what does it have to do with disqualifying me? He then talks about accusations against Lieutenant Tully, former Trooper Proctor, and Sergeant Uri Buchanan. What does that have to do with disqualifying me? He talks about actions by Sergeant Buchanan taken after he left the Norfolk District Attorney's office in support of a legal civil dispute between Ms. Reed and the alleged victims in this case. That has nothing to do with whether I should be disqualified. We talked about my voluntary withdrawal from the indictments concerning Ms. Nathan. And if Your Honor would take a look at page 6, where we have bullet points. All right, the first bullet point is absolutely relevant, and that's what we've talked about, that I'm being sued for intentional misconduct by Ms. Nathan. And we hear that Lieutenant Tully is being sued by Ms. Katani. So what? That Detective Tully has been sued by Karen Reed. What's that got to do with the price of beans, as they say? That there were disciplinary proceedings against Lieutenant Tully.
Might be relevant on cross, you'd agree?
Yeah, it might have some relevance on cross, but what has it to do with disqualifying me, Your Honor? They weren't disciplinary proceedings
Fair point.
against me. We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed, but what has it to do to disqualifying me in this case? We hear that Buchanan was disciplined. That Proctor's been sued by Ms. Reed. That Proctor has had disparaging text about Ms. Reed. There are two things that the upcoming case should not be about, Your Honor, and I'm sorry I'm losing my voice here, excuse me. One, it should not be a trial of the case that has been null pros concerning Ms. Gattani. And two, it should not be a retrial of the Karen Reed case. None of this stuff is relevant. Gattani's testimony will undermine the credibility of Detective Lieutenant Tully and Ms. McCabe, which will subject her to cross-examination by Mr. Cosgrove. Well, let's look specifically, if I can skip ahead in the memorandum. The argument that's been made a little later on in the memorandum, in which Your Honor has heard again today. And I'm looking now at page 16, Your Honor, the first full paragraph. Ms. Gattani will testify that Detective Lieutenant Tully intentionally mishandled her cell phone by tampering with and/or deleting its contents. Detective Lieutenant Tully will deny this. Mr. Cosgrove has accepted Detective Lieutenant Tully's explanation without any further investigation. Well, I don't know how the defense knows that I've accepted Detective Lieutenant Tully's explanation without any further investigation. But let's put this on a timeline. It has been the contention of the defense from the start of the case that certain items were missing from the download of Ms. Gattani's cell phone. And their explanation is that must be because Detective Lieutenant Tully deleted it. I responded to that. Ms. Gattani is a latecomer to this discussion. She is only now, in the form of either public statements or representations by the defense as to her new position, suggested that this is because Detective Lieutenant Tully tampered with it or deleted its contents. By the way, I don't know how she would know that because she was not there during the download of her cell phone and the transfer of it. But at any rate, my response as to what happened to the cell phone occurred before Ms. Gattani made any of these statements whatsoever. I don't know how it can be that I have been siding with Detective Lieutenant Tully over Ms. Gattani. I haven't seen an affidavit from Ms. Gattani. I haven't seen anything from Ms. Gattani other than hearsay, which is just a representation. And certainly, but let's assume that I do, as they put it, side with Detective Lieutenant Tully in cross-examining Ms. Gattani and in the closing argument. What does that have to do with defending my position in the Middlesex case, and how is it relevant, and how would it even be introduced? I have no idea. Let me back up and make a couple of other points. I want to turn to the legal argument, say a little bit about the law, and I suspect Your Honor has probably already looked at the two cases cited by Mr. Betterow, Commonwealth versus Dunlap, and the other case is named U.S. v. Health, which involves a complicated civil action involving the Church of Scientology and others. The first thing to say about these cases is they're Pennsylvania cases, not Massachusetts cases. So, at best, I would say they are persuasive authority, not biased authority.
I don't think Ms. Betterow contests that.
No, of course
not.
The second thing I would say is that they are both opinions in which the court declined to rule for the defense on the conflict of interest argument. In the first case, Dunlap, the decision of the Superior Court judge was affirmed by an equally divided court. The dissenting justices characterized the other side as the majority, but the opinion itself says that the appellate court was equally divided. So I'm not sure if it's even good as dicta It seems to me it has no precedential value at all, but if it does have precedential value, it was a ruling in favor of the Commonwealth. And what were the facts? In a sentence from the dissent, that is, those who believe there was a conflict of interest, the district attorney who prosecuted this case also represented the victim in a civil suit arising out of the same transaction. That is a mile away. That is a stadium away. That is a continent away from the facts in this case. I am certainly not representing Ms. Gattani in a civil suit arising out of the events that bring the defendant into court. Now let's take a look at U.S. v. Health or Health, I guess it is, which is the federal case. That does have some interesting parallels to this case. According to the decision, and I apologize for not having the pin sites, but I think Your Honor will readily find them. The defendants contended on appeal that they were denied due process because two prosecutors were defendants in a civil action filed by the Church of Scientology 10 days after the events that went down in this particular case. And they alleged, and the events that went down were a search of Scientology's office in Los Angeles, and they alleged that the raids were conducted in bad faith with the intention of violating Scientology's constitutional laws. You can look back at the memos filed by the defense and the contention they're trying to make, or one of them, is that this is a bad faith prosecution. So that applies here. What is different here is the civil suit apparently precedes the raid that the prosecutors made in the defense office in the Church of Scientology. Here, there's nothing like that. The events that the defendant was charged with in this case occurred before any involvement by Ms. Gattani, before any involvement by that matter with me. And those issues are pretty well set and have consistently been followed through. And here's another similarity between Height and the current case. I'll just read a sentence or two. The government contends that prosecutors cannot be disqualified when sued by a defendant, because defendants could then remove whichever prosecutor they please simply by suing him. Now, of course, the defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential conflict. I have not gone so far as to represent to the court that I cannot be disqualified when sued by a defendant or by Ms. Gattani. I think in fairness the court can look at it. But the federal court, the argument was that any suit complaining of an action taken in a prosecutor's quasi-judicial capacity would be frivolous and non-disqualifying because he enjoys absolute immunity as a prosecutor. Cite to a U.S. Supreme Court case. I believe as Your Honor reads through, you'll find that the court in Height pretty much bought that argument. And they go on to say that appellants have made no credible claim of actual prejudice based on the prosecutor's alleged pecuniary or personal interest in the outcome of this prosecution. I certainly have no pecuniary interest in the outcome of this prosecution. I have no personal interest in the outcome of this prosecution. And nothing in this prosecution is going to affect anything that's going on in Middlesex. I'm sorry, in Worcester Superior Court, Your Honor.
Understood. Any further? From Mr. Cosgrove, sorry.
No, I'll stop at that point.
Mr. Pepper.
Yes, thank you, Your Honor. We might as well start from the back with U.S. v. Health, Your Honor, which is 668 Federal 2nd, 1238, D.C. Circuit, 1981. Mr. Cosgrove has buried the lead about Health and about Dunlop. Those were appellate arguments post-conviction. Now, that is a huge distinction about a timely motion in advance, raising issues which could lead to a conflict. We all know that raising a conflict on appeal, when you could have raised it before, is looked at in an entirely different way. And the relevant language from Health that I would direct the court to is on page 1276, which states, given the need to promote the appearance of justice, a trial court on timely motion to wit, like here, should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. That's here.
Well, the key words there are allegedly bad faith. I'm not sure that there's an allegation in those other complaints of bad faith. There's an allegation he violated the statute. I'm not sure where it talks about bad
She
faith.
sued him for intentional infliction of emotional distress, coercion.
Negligent infliction, there's a difference.
She sued for intentional.
Negligent, but
I respectfully, Your Honor, there are deliberate allegations of intentional misconduct in the complaint, but that's, the court can obviously go back and one of us.
We took judicial notice.
Exactly.
Whatever
One of us is right.
I read
One-
this morning there's been negligent, but that's, I couldn't.
Dunlop is the same situation, Your Honor. It's post-conviction. The other issue, and I want to go back to the beginning that Mr. Cosgrove started with, he illustrates the whole problem here. He's defending himself, and I have no opinion on the merits of Ms. Gaetani's claim, okay? As a lawyer, I sympathize. But he started by telling you that this case is going to get dismissed, and all I did was turn over this. He is illustrating front and center his personal interest that Gaetani is accusing him of things he didn't do. And the conflict, the personal interest, isn't the outcome,
Accusing things that he didn't do, he acknowledged it, didn't he?
but he's justifying it and saying she's trying to do this, she's not credible. The point is this: the personal interest for Mr. Cosgrove is not whether he was wrongfully sued or whether it has any merit. His good name has been attacked, and like anyone else, he has an absolute right and a personal interest in defending himself. And again, the proper forum to do that is not while prosecuting a case in which his accuser is a witness, his co-defendant is a witness, and Ms. Gaetani is going to probably impeach, assuming she's allowed to, their star witness, Ms. McCabe. When someone's integrity is attacked, they have a personal interest, especially someone as credentialed and respected as Mr. Cosgrove. We all understand that as lawyers and judges, but that doesn't mean you get to prosecute the case. That's for you to decide, obviously. And we're talking about an appearance. This looks terrible, which leads to my next point. Mr. Cosgrove went through all of these allegations in our papers about, Proctor had this, Tully's been sanctioned, Buchanan, is literally aligned with Jennifer McCabe, which we wrote about, supporting her. Buchanan was a witness in this case too, and part of the investigation.
But not anymore.
No, but the point is this: he is looking at this in a vacuum. The public must have confidence. Part of the analysis of a conflict of interest is the first sentence of the brief that he just cited from, is that the public must have confidence in the criminal justice system. And this latest conflict is a pile on conflict after conflict after conflict in this case. And if the cherry on the sundae...
Let's just, let me slow down, because we're conflating two different issues. I'll agree with you, there's all sorts of issues that have developed over the course of these interrelated prosecutions. Mr. Cosgrove's role, though, was a latecomer and really had nothing to do with any of these other issues. So I can't sit and say I impute all of those other things to Mr. Cosgrove. And therefore, if we look at that mass of problems that have developed, he's out. Because the same logic would say the next person who sits in that seat, the same argument would apply.
Let me be very clear. I'm not accusing Mr.
I didn't think that you were.
Fair enough.
But my point is, all of those things are conditions which are already present in this prosecution.
They are.
So really the only thing that I'm dealing with is this one issue, because the rest of those things he had nothing to do with.
Well, one of them, he had his other conflict, which he voluntarily sought.
But that came out of the same exact issue.
Yes, well, that's our point. We think it's the same conflict.
I agree with you. But what I'm trying to, the point I'm trying to draw, the distinction is, all of these other problems that arose out of the Reed prosecution, real, imagined, substantial, that's really not for me to decide, right? They're all out there, all right? And they're all gonna be there no matter what. So whoever sits in that chair right there is gonna have all of those
The
problems.
difference, I don't mean to cut you off, Your Honor. The difference is that if it's not Mr. Cosgrove, the man or woman who would be sitting in that chair is not being sued by Ms. Gaetani and co-defendants with DL Tully.
That's my point. That's the only thing I have to analyze.
Okay.
That point.
Our point, respectfully, was that given the public's need for confidence, in this case, not the Karen Reed case, that's a whole nother conversation for someone else on another day. But this case is filled with conflicts, and I don't think we can all just avert our eyes to and say, but none of that matters, but we're gonna have a prosecutor now cross-examine his accuser and then say she's not credible. He also indicated, Your Honor, they're not even committing to calling Ms. Gaetani. I can't fathom how that might happen. They used careful language. They may call her. We're the defense. We don't have to do anything. We can take a nap throughout this trial, and there may be such a terrible joke of a case they present that we stand up and rest. So, of course, why would any credible, serious lawyer commit a year in advance, I'm calling this witness? We're alerting Mr. Cosgrove to what we think is his conflict in the court, and we may very well do that. The last point for this, he said there's no affidavit from Ms. Gaetani, or it's all just hearsay about, tampering with her phone. The best basis for that will be the posting online social media by a third party and long-time known critic of Mr. Kearney of messages which did not appear on an extraction report that we got from Tully of Gaetani's phone, and then we never got anything from Tully's phone. We got screenshots of what he claimed were messages. That's the basis for that. Thank you.
Fair enough. All right, so here's what we'll do. We're gonna set another date. Let me talk about this. Mr. Brady, when we selected the penciled in the trial date, I gave you a very long date, longer than I wanted. Your schedule, has it changed? Can we get this thing done earlier? Assuming it's alive?
Judge, it's probably gotten worse.
We're not moving the case back. That trial date's not gonna go backwards.
Okay.
This is a 2023 case, it's 2026. It's not going backwards. If anything, it's gonna move forward, so don't.
I know you'll relate to this, Judge. I have the usual slate of fall murder cases.
I get it, but this one's an old one, and
Right.
it's set. So I was gonna try to move you forward, but if you tell me that can't happen, then that can't happen.
I'm sorry.
All right, but understood. This court is willing to take this case much faster than the current schedule.
Appreciate that. We do have a few other pretrial matters to address. Your Honor mentioned the motion to dismiss. Maybe we should schedule that.
What we're gonna do is this. I'm gonna take this under advisement. We're gonna pick a date right now. And either we do a motion to dismiss that day, or we're on for appearance of new counsel that day. All right? One or the other. We're gonna know. I'll get your decision beforehand. Now, I am open to the idea that if I accept there's a conflict here, I haven't made that determination yet, but if I accept there's a conflict, I'm open to the idea that it's resolvable by having someone else step in and cross-examine her. I think that solves all of the issues. So that might be the easy way here, so everybody can get this thing moving and have this trial, which all parties seem to desire.
Judge, just on that point, I appreciate you kind of reflecting your thought process. But, you know, even if counsel stays on the case, but doesn't actually do the questioning, it still remains that there's a conflicted counsel on the case, and the jury ought to know
You and I both know
of that interest.
Mr. Brennan, you and I both know this happens with some frequency, and we work our way around it. All right? The jury's concentration in this case is on the events of the case. Now, Ms. McCabe's credibility, I expect to be a robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But Mr. Cosgrove raises a reasonably good point that, you know, there's been some recent case law talking about, you know, the police can't create their own exigency. And to some extent, the defendant has created his own exigency here. Because in fact, the plaintiff in that case is suing because the contents of her phone were put on the internet. The defendant did that. So there is some, you know, you gotta be fair to both sides here and say this is something which only happened because of steps taken by the defendant.
Well, Judge, I don't want our lack of response to that to be perceived as an acknowledgement. I don't want to address that for a ton of obvious reasons.
I'm basing that simply on what I read in her complaint,
Sure.
not on anything that's been represented to me today.
Right, exactly. And so, just a couple rewinds here, judges, that the government themselves, in Lieutenant Tully's own affidavit at the time of this, back in December of 23, swore in the affidavit that Ms. Catani was a witness. And so I don't think the government can do a 180 and say, oh, she's not really a witness.
Well, she was a witness, but she was a witness at that point. They were trying to indict your client for some sort of conspiracy charge, which failed.
Right.
Right. And
but it apparently
the
still alive and under investigation.
Well, that's that's another matter. I've told you I have no authority to affect that. What I do know is that was no prost, not no prost, no build.
No bill.
Even worse. Okay. That was no build. So I can't imagine a circumstance where I would allow evidence in about a no build issue. I would remain to be persuaded on that.
So what, and just to go to the lowest hanging fruit on why Ms. Catani would be a witness, there's all sorts of screenshots and text messages. You know, we need these things authenticated before we use them.
I'm not necessarily saying that can't happen.
There's all sorts of reasons, Judge.
I get that, but
no one's trying to trigger a recusal. There's a lot of good reasons why she's involved in this. By the government's own affidavit.
I'm not discrediting what you're saying. What I'm saying to you is, I think there's a way around this. And I don't know that a closing argument is going to change that, because the closing argument is based on what's heard at the trial and on Ed, in this court's view, and in the proper practice, be confined strictly to the evidence that's presented before the court. So, you know, it's not.
I appreciate your reflections, Judge. If I could just have one moment.
Yeah.
Thank you very much, Your Honor. That's all we have. And just,
Let's pick a date.
are you late February, March, okay? Early March? What would you like, Your Honor?
Let's go later in March.
March 27th?
Is that Friday? Fridays are generally best.
It is a Friday.
Do it on Friday.
Thank you.
I don't know if we'll be in this room. I'll have to consult with the document who was generous and had me in this room today.
I want to say one other thing, if I could,
Sure.
Your Honor. I am concerned that some protective orders that have been issued by the court have been subject to violations. I'm not prepared to address it today, but I want to put the defense and the court on notice that I do think there's a basis for that argument, and I will plan on raising it with the steering.
Well, raise it first with the other side, so that they're aware of your concerns.
Oh, I will, of course.
All right. If it's not resolvable, then the court will step in. Nobody benefits by undermining the protective orders. Look, again, the way this court looks at this is that this is an important First Amendment issue which should be decided by a jury of the defendant's peers to decide the mores of our society, whether or not this is journalistic activity or it's not journalistic activity. Let's try to focus on that, folks.
I absolutely agree with that.
Okay? All right, anything else we can do today? No, sir. March 27th, the purpose of that hearing to be determined, but it's going to be one of those two things.
Thank you.
Thank you very much.
All right.
All right, both matters continue to March 27th, time and session.
Court, all rise, please. Your heads in the courtroom at this time, please. Thank you.